very sloppy work by the Supreme Court. But, I mean, if you are the Supreme Court, the Republican Supreme Court, then, all you got to do is decide in favor of capital.
Which side are you on?
Another ludicrous story comes out of the Supreme Court. The
Surprise.
the anti-worker Supreme Court released another anti-worker decision, if you can believe it. This was as it relates to Starbucks and the Memphis 7. There were 7 baristas who were fired by Starbucks in Memphis amid a union campaign by Starbucks Workers United. The NLRB, because the firings were so egregious, sought a 10J injunction to, and so just to kind of general overview of 10J injunctions, basically they do not totally adjudicate on the completely on the merits. I mean, there are some merits involved in it, and you have to show like a reasonable amount that the NLRB's assertion could be true. But what the 10J injunctions do is they enjoin a company from continuing to act in a certain way that would dissuade people from participating in union campaigns or from showing union support. And so the NLRB sought a 10J injunction and to order Starbucks to rehire these 7 baristas in Memphis, while the process was going through the NLRB and the administrative law judge would, because these things take years, and so the 10J injunction is like, okay, well, while we figure everything out, because it's reasonable to expect that the NLRB is going to win. It's possible that they don't ultimately in the end, but because there's a reasonable amount of confidence that they're going to win, in the meantime, the 10J injunction says you got to rehire these people, or you got to stop discriminating again, or you got to stop doing this or that illegal anti-union behavior, right? That's what a 10J injunction does. And so there are 2 tests that a court can use to rule on these, right? And so the NLRB has argued for a 2-prong test, and Starbucks argued for a 4-prong test that, as you can imagine, is more strenuous and more difficult to meet. And so that was the source of the case. Does the NLRB have to meet the 2-prong test or the 4-prong test? The Supreme Court sided with Starbucks, saying that you have to meet the 4-prong test. And so that's why Brandon Magner said that materially, this is probably not going to have a huge impact on how the NLRB pursues 10J injunctions, because even under Jennifer Abruzzo, the degree to which the NLRB pursues 10J injunctions is still relatively small, and they only do it in these bulletproof cases. They're only arguing on the 2-prong test so far, but all of the cases, so Brandon argues, an NLRB attorney, so, I'm willing to kind of generally trust that is the case, and it is the case that it's not as if the NLRB is going around seeking 10J injunctions all the time. It is fairly rare, and so Brandon says, generally these cases are going to meet the 4-prong test anyway, right? But the NLRB has only been arguing the 2-prong test so far, and that's how judges have been deciding. KBJ, in a partial dissent, said that, the NLRA says that generally we should be deferring to the NLRB in matters relating to the adjudication of the National Labor Relations Act, and this court is stepping all over that, and that's obviously true. But SCOTUS blog has a good explanation of the 2-prong versus the 4-prong test, just to help you understand exactly kind of what's at stake here.
Hey, 5 seconds, just wanted to say that this is only possible because of our donors. If you want to see more of this, then consider donating yourself at tvlr.fm/donate.
So, reading from SCOTUS blog, specifically, How hard should it be for the NLRB to get an injunction in a case like this one? The statute doesn't say much. It simply provides that the court should grant, quote, such temporary relief as it deems just and proper, right? So that's all you've got, and so you kind of have to go back, look at history, look at case law, things like this. For its part, Starbucks points to a traditional 4-part test that courts have developed for deciding when to issue preliminary injunctions, sometimes called the winter test. That test calls for 1, consideration of the likelihood that the party seeking the injunction will succeed on the merits, 2, whether the party will suffer irreparable harm without preliminary relief, 3, whether the balance of equity tips in that party's favor, and 4, the public interest. Starbucks argues that the Supreme Court has applied that standard in many contexts and that the court requires a specific textual command to opt out of it. For Starbucks, the, quote, just and proper language is far too imprecise to justify a departure from the traditional standard. Starbucks contends that the NLRB's test applied by the lower courts here is much more lenient because it considers only 2 factors. Whether the NLRB can show, quote, reasonable cause to believe that unfair labor practices have occurred and that injunctive relief is just and proper. That might... So that's 1 and then 2. That might sound so vague as to be basically the same as the 4-part test, but it is not. Most importantly, the reasonable cause standard, unlike the likelihood of success on the merits factor in the traditional test, requires considerable deference to the NLRB, which need show only, quote, some evidence and not a, quote, not frivolous legal theory, with all factual and legal uncertainty being resolved in favor of the NLRB's administrative expertise. Which is, talking that, and that's the reason that the 2-prong test should be what is gone with, because it requires deference to the NLRB, which is what in other parts of the NLRA prescribes. It prescribes deference to the NLRB because of their administrative expertise, right? These are labor lawyers. These are people who spend their time learning and adjudicating and practicing labor law, right? That's going to be a lot different than a Supreme Court justice who has a more general expertise, right? That's kind of what we do in situations where we are faced with an area that we do not that we do not know much about. And actually, Brandon Magner, I just remembered this, pointed out some just factual errors in the majority opinion. So here's from Brandon. Thomas gets this portion of the opinion totally wrong. 10J injunctions can only be authorized by a majority vote of the board's members. They cannot be pursued solely by regional offices, which is what Thomas says. Thomas is saying that regional offices are going willy-nilly seeking 10J injunctions, and that's just not what happens. For one, it's not that common for the NLRB to seek a 10J injunction, and for 2, it requires a majority vote of the board members. So that's kind of amazing that Thomas just gets a factual error wrong there. Very, very, very sloppy work. Very sloppy work by the Supreme Court. But, it's, you don't really have to justify it too much. All you got to do, if you are the Supreme Court, the Republican Supreme Court, then, all you got to do is decide in favor of capital. And that's what they did here. So they served their purpose.
You just saw a clip from the Valley Labor Report. We are live every Saturday morning from 9:30 a.m. till 12:30 p.m. And we pride ourselves on keeping all of our content free to everybody so that we can talk to as many working folks as possible. If you support the work that we're doing, you think that it's important, you think that it's good, then consider making a monthly contribution to the project, and you can do that on our website, tvlr.fm.